Yes, Mr. Chaskalson.
Thank you, Chair. Before we broke, Commissioner Khumalo had referred you to 3 letters sent by Chief Mapie and was interested in your response in relation to these 3 letters. Maybe if we can take them sequentially. The first one is that was the letter of 20 June 2023 and is headed Upliftment of Suspension, and it's addressed to you by Chief Mapie. Do you have any comment on this letter?
Mr. Chaskalson, what page are we looking at?
It's 179 of the Mapie annexure bundle. This is the letter in which the chief redeployed.
Maybe shown on screen if there's no. I don't think there's any issue with it or not. Oh.
Okay. It's the letter where the chief indicates that he's now going to redeploy Brigadier Mkhwanazi, as he then was, to the bylaws department when his suspension is uplifted.
Thank you, Chair, Commissioners and EL. This letter is emanating from the previous letter where I've advised the Chief of Police in terms of the upliftment of suspension. It came with no conditions to either utilize the employee in another capacity. If you recall, when we went to discuss the disciplinary procedure on collective agreement 16.4, it's very clear: you suspend or you utilize the employee in a different capacity. My advice, Chair, it sought to guide the chief that we need to adhere to the instruction of the accounting officer and the discussions that have where this was decided. And number 2, there's a transfer process in the city that if you're going to transfer an employee to a different capacity, there must be a written motivation, and there must be a consent from the employee if that transfer is going to happen. I'm emphasizing it's an advice. The chief is dealing with operational issues at EMPD, is dealing with disciplinary issues at EMPD. But the minute the issues go to bargaining council, HR is left alone. In fact, I've been saying to the ER team that let's get to a situation that departments, if there's a matter that goes to bargaining council, they lead it. We just advise even at that level. The concern I had there, Chair, it was that we're not talking to the talent acquisition policy. There's a paragraph there that talks to transfer, how transfer must be done. Number 2, if I can read maybe the last paragraph on this letter, where it says, due to generic scope of Brigadier's Director EMPD job description, it does not have any impact on the work or performance that is required from any senior manager. If Brigadier Mkhwanazi could, the erstwhile Brigadier Mkhwanazi could have decided at that point in time to declare a dispute against the city, it would have probably said you didn't follow the talent acquisition policy on transfers, and he could easily declare a constructive dismissal. That you're allowing me to go and do a work of a law enforcement by law enforcement, whereas you appointed me as Deputy Chief of Police on specialized services. If he fails there, again, probably was going to go through another disciplinary process. We could have been found wanting. So I was just advising Chief of Police that guide against. And he made it clear that he is comfortable with how he has handled his matter. I didn't take it any further. It ended there.
But do I understand you correctly that you appear to be addressing transfers in general? You do not appear to be addressing transfers in the context of a disciplinary process. Am I understanding you correctly? I'm just seeking clarity.
Thank you, Chair. Chair, I've explained that in 16.4 of the DPCA, it says, when I read it earlier on, it's either you suspend or you utilize a person to another capacity. My interpretation of that is you might not suspend from the beginning, but you can utilize another, and it comes under one paragraph. My understanding as an HR practitioner was you do one of the two. When you uplift that, then you go back to a substantive position. It's either you are sitting at home or you are referred to another department. So I'm clubbing that as part of the suspension. That we can suspend you and go and sit at home and you earn a salary for free at home, or we utilize in another capacity. I'm addressing that. Number two, I'm adding to that.
And you are not using transfer for that. The use in another capacity, you are not using transfer for that. Or would you still use transfer as well?
Chair, you can use transfer if you want to. But all I'm saying, remember, even if it's a suspension, we give you
let's
apply.
Let's forget about the suspension.
Or
just
going
focus
somewhere.
on use in another capacity or transfer to some other position.
In those incidents as well, Chair, you must get a written motivation and there must be consent. And in this instance, I didn't see that.
Maybe I'll sound like I'm already beginning with the intrusive questioning, but I find it strange that you would have to first get the consent of the employee where you are transferring because there's a disciplinary process afoot. That's where I have a difficulty. Anyway, please proceed, Mr. Gxasheka.
Can I just clarify that the letter that you're referring to, your 15 June letter, is the letter at page 178 of the Mapie annexure bundle. It's JM30. Is that the letter you were referring to?
That's correct.
So you responded to your letter and or you've explained your letter and responded to Mr. Mapie's response. The next letter from Mr. Mapie was the following day, which was the 21st of June. And in this letter, he was indicating that because of the collective agreement provisions, if the charges against then Brigadier Mkhwanazi were to proceed, the charge sheet would have to be served the following day, 22 June. And he was motivating strongly for those charges to be served, and he addresses a letter to Advocate Bahari and to yourself. What was your response to this letter?
Before I could respond to this letter, Chair, There's other events that happened. But before I talk to those events, I would like the Chair to refer the Commission to the statement of Chief of Police on paragraph 102. I would like to read.
Sorry, paragraph?
102. After I've read the statement of Chief of Police, I would like to refer through you, Chair, and read the paragraphs 69 and 70 of Mr. Tolani Nceza's statement.
Paragraph 102 is at page 28.
Page 28, yes. Thank you. On the 21st June 2023, following discussions initiated by Ms. Gxasheka and Advocate Bihari, HOD Legal, I was pressurized to hand over the docket relating to Brigadier Mkhwanazi to Advocate Bihari. This I did as per Memorandum of Advocate Bihari, dated 21st June 2023. Thank you. I'm going to read Tolani Nceza's statement, page 23, paragraph 69 and 70.
Sorry, page 33.
23.
Or 23.
On the 21st June 2023, Chief Mapiyeye updated me about his interaction with Dr. Mashazi and Advocate Bihari, who has advised that there was no case against Brigadier Mkhwanazi. Chief Mapiyeye subsequently instructed to withdraw the internal investigation into Brigadier Mkhwanazi's field. I was informed on the 22nd June 2023, Chief of Mapiyeye withdrew the internal investigation. I was of the view that this letter has no force of law. Chief Mapiyeye couldn't withdraw an internal investigation that was already completed and had been the basis for disciplinary proceedings. The ship had sailed. The internal investigation was at the stage already completed and my joint attorneys have already been briefed, and I was of the view the disciplinary proceedings must continue, and the Chief of Police was factus official. If I can go back now to the letter of the Chief of
Before
Police.
you go, sorry to do this to you. I had hoped that you would read 103 of Mapiyeye, unless you're still coming back to it. Because that's where he says the pressure.
I'll gladly do that.
103.
Yes.
Yes.
I was also instructed to withdraw charges against Mr. Brigadier Mkhwanazi. I addressed a letter Brigadier Mkhwanazi advising that I had taken a decision to withdraw the internal investigation processes and redeploy him to substantive position. The effect of this letter was not to withdraw the disciplinary process. In fact, it was deliberately meaningless, as it purported to withdraw an internal investigation, which at the time had been completed, and the basis which charges have been formulated. This I did in a bid to stop the consistent harassment I was facing from the city manager and the two agencies. In fact, therefore, the disciplinary procedure has been withdrawn and attached. I think then we're talking to JM 33.
So-
I was going to come to this,
That's fine.
Commissioner. I was going to come to it. In the statement of the Chief of Police and Tolani Nceza, they are contradicting itself when it comes to this matter. Chief, he says they had an engagement with HODHR and legal. I refute here that I was part of that engagement. I don't think I would have agreed to such. Hence, later on, I requested that let's have a forensic investigation done into this whole mess. Xolani Chair says the discussion took place, according to Chief, the discussion took place between Dr. Mkhwanazi and Advocate Kim. I'm not going to exonerate myself in this mess. Hence, I continuously, the latest before my suspension last year, and said, let's get to the bottom of this. But if somebody is listening carefully, there has been continuously discussions that are taking place outside myself. Let alone that when I engage the city manager, sometimes I find that legally she's been well briefed. But we'll have our discussions and debates on the issues. It's a very confusing situation between these two statements, but I'm reiterating, I don't think I would have agreed to this if we engaged on it. There were discussions that were taking place between Chief of Police and legal without me taking place. The file, I've kept on asking for a file desperately as late as 2025. If we had the file, I mean, they are talking about the copy, where he says, by the way, in that discussion, if you read paragraph 2 of his letter, he says, as discussed earlier today, I wasn't part of that discussion, but he says I was. Or I'm just copied, I don't know.
You're not copied. You are an addressee together with Advocate Behari and Mr. Erasmus.
Thank you, Sean. He says, as discussed earlier on and agreed upon, there's agreements that took place, and I want to reiterate here, I wouldn't agree to such.
Did you respond to this letter?
I've never received the letter. I don't know the letter.
You don't remember receiving it?
No.
And just to be fair to you, Advocate Behari, when he gave evidence, he said he cannot recollect whether you were present at the meeting. I just thought I should be fair to you and give you that.
I was never. To my surprise, then the chief writes the letter of the. Can I move EL? The letter dated 22nd June 2023. It's on page 180 of Chief's annexures. That's where Chief, we are here now because of this letter, where he withdrew this process. Again, Chair, Linda Gxasheka is not mentioned here. Hence, I'm saying maybe I should give a statement. What is good for the geese is good for the gander. When it suits them, they include me on matters. When it suits them, they want to exclude me. Maybe there's a reason they excluded me here, because I would have challenged this. I think I'll stop there for now. I haven't read the letter of the 22nd June 2023, but maybe I should read it to the Commission. The heading is addressed to Julius Mkhwanazi, Director, Specialized Services, Mr. G. Mzolo, Deputy Chief of Police, and Dr. Mkhwanazi, City Manager from IJ Mapia, Chief of Police. 22nd June 2023, as stated, disciplinary matter is the subject. J. Mkhwanazi. On the 2nd February 2023, allegations of a very serious misconduct were received from the media query from News 24 journalist Mr. Jeff Wicks, which implicated yourself and which subsequently investigated by Internal Affairs Section EMPD. To date, the matter has not been concluded. I, as the Municipal Police Commissioner, he makes a demand there. Take this decision to withdraw this internal investigation process under the case number 0302-2023, and herewith redeploy you back to a substantive position, Director, Specialized Service, as from 26 June 2023. Hope you find this in order. Thank you. He's demanding that, so it's very clear command. I, Chief Mabie, with his power, without anybody usurping, he makes this decision on his own. I will end there for now. Yeah, thank you.
You've addressed most of the issues in relation to the disciplinary proceedings against Brigadier Mkhwanazi. I just wanted clarity on one issue, which is at the top of page 22 of your statement, paragraph 65. You write, based on the instructions of the accounting officer, my letter sought to advise and guide, and based on that, if the charge sheet is ready to be served, the investigation is concluded. There's no reason for deployment of the employee to another position unless it's dealing with financial related matters. Now that seems to be a reference to your letter of 15 June. Is that correct? Now you say based on the instructions of the accounting officer. What instructions are you referring to?
If you read my letter, I think the first paragraph, it says it came to my attention, first paragraph but second sentence, that it came to my attention that Mr. Mkhwanazi has been deployed somewhere else. So I was referring to the discussion I had with the accounting officer. And as I said, that we normally have the legal debates with her. And in this instance, obviously, the issue of the transfer we discussed with the commission were raised versus the utilization of capacity. Thank you.
So it's still not entirely clear to me. What were the instructions that Dr. Mkhwanazi gave you? What are you referring to?
The debate that was continuing throughout when we deal with LR matters, but even in recruitment and so forth, but specifically in LR matters, is you have to take ownership of LR matters. You must have answers all the time. And when things are happening outside my space, I'll be reprimanded. So again, the moving of Deputy Chief of Police Brigadier Mkhwanazi to another division, it was done by Chief. So the debate and the engagement we have is, why did I allow that to happen?
So were you given an instruction?
I must attend to it.
You must attend to it. You must put this right.
Yes.
I just have to clarify. So the instruction from Dr. Mkhwanazi was stop this redeployment. Is that what you're saying?
Yes, address it.
There's the next topic is cross-referring back to, sorry, I'm in the wrong, I'm in the wrong file at the moment. It's cross-referring to paragraph 3.3 of the notice, where there was an allegation that you failed to act to resolve an ongoing disciplinary issue where 6 officers from the Drug Enforcement Unit who report to Brigadier Mkhwanazi were arrested by IPED for allegedly extorting 80,000 rands from a member of the public, purportedly evaded disciplinary action, was subsequently incorporated into the City of Ekurhuleni VIP protection detail. You addressed this from paragraph 67. Do you want to give the Commission your response?
This matter, it came to my attention during the proceedings of the Madlanga Commission inquiry. And if I could recall, I'm not sure if it formed part of my charges. And when I followed up with EMPD, I think I must explain another issue that is very critical and imperative to be comprehended here. EMPD, it's got its own internal unit, internal affairs unit that deals with investigations. Not only for EMPD, by the way, even for the rest of the city, we utilize their capacity. I go to them to assist us. So their matters specifically, when they come for investigation, it's done by them. In this instance, when I followed up in December, the department told me that they have not yet commenced with the internal investigation onto this matter. Prior to my suspension, I think a day before I was going to be suspended, the executive mayor and the city manager called me to sensitize that they are intending to suspend me. In the discussions we're having at that time, but I don't think it's for with due respect for today. Then they mentioned an issue that the VIP protectors that are allocated to myself, Advocate Kemi Bihari, the acting CIO, some of these guys that are being investigated by IPID. Hence I said, the minute I was suspended, I requested that can I go home? And I told them that they go to the Eastern Cape. By the way, they say I'm from Limpopo, I'm not from Limpopo. I said to the executive mayor, you give me other reasons to run away. Other issues, I think, Commissioner Khumalo, you are aware, they were part of the assessments. I did give all the incidents that have gone through. In my house, in myself, where I had to have break-ins in my house, men with 5 rifles in my house, followed by cars that are branded by EMPD. They have EMPD branding. When they are searched, they don't belong to EMPD. After being suspended, I ran to the Eastern Cape. I'm followed in a hotel where I was sleeping. 2 men entered my room, and others that are in that report. So because I've shared at a high level with the executive mayor what I've been going through, then I said, now that you're telling me, excuse me, there are VIPs that are allocated to us that are being investigated by IPID. I must be permitted, you can be permitted to go as long, wherever. So to come back to the issue of the day, this is the letter where they told me that after I engaged them, that they've withdrawn these colleagues of theirs from providing VIP for us. I've got WhatsApp from the director of that unit, where he has confirmed after I was suspended that they have not yet commenced with the disciplinary process. They are waiting IPID. I'm not going to discuss IPID issues here. I think I listened briefly on the IPID colleagues that were here and how they've explained to the commission how EMPD manages their investigations. In some instances, they start with the investigation and suspend employees. In others, they wait until you go to court and you are convicted, only they deal with you on that. In summary, EL, this was never brought to my attention, the 80,000 bribery matter. It's still sitting with EMPD. I don't know now from December, January, February, if they've acted on it. Thank you.
So just to clarify that your evidence is that you played no role in this matter whatsoever, that the investigation never left EMPD. And the first you heard about it was in November last year.
It was after my, yes, it was prior to my suspension when the executive mayor and the city manager sort of highlighted.
Where you were told that,
yes.
that these municipal police officers who had been on VIP were now had been charged in relation to this extortion and were being redeployed back to the Drug Enforcement Unit.
Yes.
Thank you.
Sorry, Mr. Chair, just a matter of clarity. Third line of paragraph 67, you say, I'm still awaiting finalization of the investigation in this matter, since there are no names provided. Are you referring to the names of the alleged extortionists, or whose names are you referring to?
Yes, yes.
Okay. And what's the import of the part that says, since there are no names provided? What are you seeking to convey there?
At the time, I was referring to the implications from here. It just talked to the 80,000, but then from the memo of EMPD, I wouldn't know, Chair, if it's only those three that are, excuse me, they are mentioned on the memo. It could be more or less. I think that's what I wanted to emphasize on.
All right. Thank you. Thank you, Mr. Gxasheka.
Thank you, Chair. We're now going to go to a number of topics where I, for one, don't need any amplification of your statement, because I think the statement explains certainly satisfactorily to me. But if there is something that you nonetheless want to say, you must do so. The first topic is the topic that you address from paragraph 70 to 81 about restructuring of the city's disciplinary and grievance procedure. Again, there's nothing that I propose to canvass with you tomorrow in this regard. I'm happy, unless there's something in particular that you want to raise there, I am just happy to move on from that part of your statement.
Thank you.
You don't want to say anything on it?
There's one thing I can highlight here through you. There's one thing I can highlight that I think there's a misperception that has been created to you and the public, that the changing of disciplinary procedure has been an ongoing matter. The reason I mentioned my predecessor, I won't mention her name here. In 2017-18, when she arrived, the issue of legal costs started there. The panel that used to be solely for HR, it was stopped. The whole procurement process and panel management of legal external lawyers, it was then done through a legal department. Even the budget, it was moved from HR to legal. So what I wanted to emphasize there, we have been in the city continuously changing delegations and disciplinary procedures as we feel fit and deemed to do so. Thank you.
Thank you. Yes, Mr. Gxasheka.
Gxasheka, I think the only issue we needed to clarify, and Chair raised it with Advocate Behari, was who is the drafter of LLG 22? Because it appears to be a legal document or something close to being a legal document. And it was not clear who the drafter was, because we were in agreement that it was not Dr. Mkhwanazi. And Advocate Behari said it was not him. So can you just clarify who drafted this document?
The drafting of that particular annexure, it was myself, Chair. But if we were to check on page 100, the one that was drafted by my predecessor as well. So there's a standard way of doing it. Thank you so much.
Why I raised the issue I raised with Advocate Behari was because there was what appears to be legalese in certain parts of the document.
Okay, thank you. Thank you.
But who says HR specialists can't draft legalese?
Thank you. We try.
The next topic is a the labor relations processes regarding the dismissal of Mr. Mkhwanazi, and that's addressed from paragraph 82 all the way through to 92.15, and then the issue of service of notices at Mr. Mkhwanazi's home is addressed from paragraphs 93 to 97, and then there's a further paragraph on the broad topic relating to Mr. Mkhwanazi's qualifications at paragraph 98. Again, I don't propose to ask you any questions about this tomorrow. I don't need you to amplify anything in there. I'm not saying that Mr. Mkhwanazi was definitely guilty, but I am saying that I certainly cannot criticize the institution of disciplinary proceedings in the light of the facts that appear to be common cause in that regard. I don't know if there's anything that you would want to amplify in that regard, or whether we can move forward.
I'm not sure if the issues of the car that went to his house is part of this. But the first thing that I want to focus on, Chair, when you go to annexures of Mr. Mkhwanazi, his CV that he brought here, he changed it when it comes to advanced labor law from NQF level 7 to NQF level 8.
I know that is in your statement. I don't want us to get into that detail unless you have a reason to, in part, because the dates of the qualifications are different, and it is at least possible, I don't know that it is correct, that Mr. Mkhwanazi might have had the NQF7 qualification at the time that he first applied for employment at the city, and at a later stage may have upgraded it to an NQF8 qualification. But I don't want us to spend time on what is essentially a labor dispute between the city and Mr. Mkhwanazi, and that will be ventilated or is capable of being ventilated fully in the labor courts if that's where it's going.
I've said earlier on through you, Chair, as I'm testifying here, I'm being persecuted by the city of Ekurhuleni. And Mr. Mkhwanazi spent a lot of time on this matter. I'm perceived as a very cruel person. I won't speak too much on it. The matter of Mkhwanazi, from what I heard now, is in an arbitration de novo process, because the commissioner who was dealing with the matter passed on in December. I also heard that the city might intend to reinstate or settle Mr. Mkhwanazi. And majority of the changes that the city has done on the matters that I'm implicated here are based on the testimonies that were made here. The challenge of how Mr. Mkhwanazi's matter is managed is going to change the culture of Ekurhuleni forever. If we're saying employees misrepresent qualifications and it's okay to do that, and then you come with a debate that, boom, all of a sudden in 2025, my qualification has changed. When I went to testify there, He mentioned here, I think I testified 23, if it's not 13 days. I kept on saying to the commissioner and Mr. Ngeza and his representative that if Mr. Ngeza give us a transcript and as it was required and a confirmation affidavit from SAPS, I'll be the first one who goes back to the employer and say, reinstate Mr. Ngeza. Has never done that. His matter started in 2017.
I know this is something that you made clear in your statement.
2017, he started with this. Matter started in 2017. When my predecessor arrived there, Ekurhuleni, we were about to declare, a dispute was declared, we were about to defend it. They've decided with Mr. Ngeza to settle. The employee that was settled, he was an internal employee who declared a dispute. The second time when he asked for a salary review, I know we're going to come to my salary review. I asked him, Mr. Son, why are you doing this? He says, I must compete with Golan and be paid the same. Why? I'm more qualified than him. I asked him when I went to testify and said, you, both of you, you went to Vista, be Juris, please confirm to me what happened. He said he's never seen Mr. Ngeza graduating. Now we're talking Juris, we're not there. The UNISA issue, everybody is got an LQF level 7, those who went to that course, credits 24. But in the last one, conveniently, after he has been dismissed, they are changing from NQF level 7 to NQF level 8 with credits 48. All I needed to be known is that we're standing by the DC and the outcomes thereof until Mr. Ngeza bring the transcript. But it's not my role anymore because I'm outside. But I'm standing with that. If I was in the city, I was still going to say that, can he provide a transcript? I said there when I was testifying, I went to UNISA to look for my transcript. One day, I arrived at 8 o'clock from Germiston to Pretoria. I was having a meeting at 10 o'clock. I was back in Germiston at 10 o'clock. Mr. Ngeza could have gone and got his transcript. I will not dwell, with due respect. I know you're guiding me, evidence leader, but I think I needed to just share a little bit of Mr. Ngleza's issue. I'll talk to issues of political issue. I won't mention names at a later stage. Thank you.
Thank you. The next topic is the disciplinary action against Mr. Spies. Again, I have just one question here. I understand what the allegations against Mr. Spies are, that there was a contract that had been extended for a period of 3 months, and that the allegation is that he was aware of that the extension terminated after 3 months, and yet he allowed the contractor to remain in place beyond the 3 months. You say in your statement on 2 separate occasions that the act of Mr. Spies amounts to fraud and corruption. That's 34, at top of page 34, and then at a later stage, I've lost my reference, but it is stated again. And it's just not clear to me. I mean, I can understand why this may be misconduct, the allegations, if they're true, but I don't see fraud and corruption, and I'm not sure if there's anything that you want to say in that regard.
Thank you, Chair. I'll be very quick. I just need to offer a clarity. I think paragraph 1699 to 104, it's talking to 2 issues. It's talking to I'll call it an evergreen, but it's not necessarily an evergreen contract because it's a contract that started around 2014. And it kept on going on and going on and going on. I won't dwell on that. I'm sure you don't want me to dwell on that because we need to save time. I get that. Paragraph 100, Chair, it talks to issues of his resignation where he claimed that he has retired, whereas we all know he came and said here, I think he might have worn a uniform that he went and worked for Swan. And the issue that I was raising there is when you are retiring in the city of Ekurhuleni and take early retirement, there's benefits you receive. He's receiving about 5,000 every month, 5.7 from Ekurhuleni, but he's also receiving the same benefits at Swan. And in his letter of resignation, he said he's taking early retirement. He wants to go and spend time with his children. But then in his statement, he goes further and creates a misperception here that he was ill-treated. He left because Ekurhuleni didn't treat him very nicely, but voluntarily in his letter of early retirement, he says he wants to go and spend time with his family. But Chair, as I say, I think that's all I wanted to clarify really. I don't think I want to dwell on this thing.
Is there any prescript, because your complaint seems to be the fact that he's now working for Tshwane Metro. Is there any prescript that says he can't? Is there an Ekurhuleni prescript that says so?
Chair, my focus-
retire and go work elsewhere.
Yes. If he resigned and said, I'm resigning to go and work in another company, wouldn't be paying that 5.7 every month. In fact, for one medical aid, I think Bonita's where he is, we're paying about $1 million. So it's a new thing where now it's him and another employee who went to PRASA, where employees starting to say, I will look like I'm taking early retirement so that I benefit in this employer, medical aid employer contribution. And it's something I was discussing with finance before I got to stay at home, that we need to revise that policy because it's becoming a problem. Now, can you imagine if we're going to have 100 people who live in Ekurhuleni and go to a sister municipality? We bear the cost. Yet that he's still benefiting that municipality, benefiting twice.
You are talking revision, and I asked you about an existing prescript. Does the fact that you are talking revision mean that there's no existing prescript that proscribes what he has done, or that says what he has done cannot be done?
To me, it's a misrepresentation when you say, Chair, I'm taking early retirement, knowing very well it's end of February. It's your last day, the 28th of February. 1st March, you're going to another municipality. And the reason I'm talking issues of fraud, because there's the money, the cost involved. That 5,700, Chair, we could be employing a general worker and improve on service delivery. City of Tshwane is benefiting, yes, for having that capacity, but highly possible they are also benefiting in the sense that it's either they don't give him that money, or if they do give him the money, he's having a contribution twice. It's a double benefit. And it can't be clear. To me, it was intentional when he decided, I'm not going to say I'm leaving to Etswan. Because in his resignation, he says, I want to go and spend time with my family. But I'll leave it at that, Chair. I hear your point as well.
I'm just thinking if we don't have the full picture as to what's happening in Tshwane, I wonder if we are able to reach a categorical conclusion about fraud/misrepresentation if you do not know what the picture is at Tshwane.
I don't know the picture. All I'm saying, Chair, is he could have said, I'm resigning, I'm going to Tshwane, we'll have a different discussion. So I feel there is a misrepresentation.
But if he's entitled to retire, I'm sorry, Mr. Shaskalson, to sound intrusive already, but if the prescripts allow him, both in terms of age and whatever else, to retire, why should he not retire? Because even someone who's reached the mandatory retirement age may retire but still go work elsewhere.
Chair, in most organizations, you're not going to get a benefit that says you retire, and therefore we're going to carry you until retirement at 65 and beyond. When you retire, they pay you your money, and that's it. So I feel where there's a misrepresentation because there's this special benefit you get when you have early retirement. That's all I was raising.
Thank you, Mrs. Gxasheka.
Sir, can I just clarify your answer, the way you're responding to the chair? You haven't said to the chair in answer, you haven't said there is a prescript that prevents him from doing this. Remember the chair asked you that question and you didn't say, yes, there's a prescript that prevents what he has done. So that must mean from your answer that there's nothing that prevents him. Prescript, as in you may feel it's wrong what he has done, it shouldn't happen, but there is nothing in writing, which is law, policy, regulation, that says he can't do this.
Thank you, Chair. I've responded to that, Commissioner. I did say that
I'm asking, yeah, no. Maybe I'm slow this afternoon.
No,
with me.
no, you did not. I think I asked you that question more than once. You did not respond to it. Sorry. Yes.
Can I ask it this way? The conditions of employment at Ekurhuleni municipality allow a 55-year-old to opt. So you have a choice. You can either resign or retire. And when you choose to retire, because it's an option, you are entitled to post-medical aid subsidy by the municipality. So he has exploited that rule to his benefit, and that's your grievance. So it is allowed, but you are saying in future you want to change it so that people don't exploit it to the disadvantage of the municipality.
Yes.
So where you say it's fraud and corruption, it's not because he's breaking any rule, any policy, any law, because it's quite a serious allegation to make. And the question about is there a prescript that says he can't do what he did is to try and get to where do you get that it is fraud and corruption. Now, am I correct that if there is no prescript that precludes him to have left when he did and to get the benefit from Ekurhuleni that he continues to enjoy and to be employed elsewhere, having left you the way that he did, if all of that is not precluded by any prescript, then it cannot be fraud and corruption. If there's no law or rule or policy that says he can't do it.
Thank you, Chair. I'm not sure if he shared with you in his statement that he even amended the form. The form talks to retirement, resignations, the termination form, and others. He added with a red pen, early retirement, he himself. And I'm going to reiterate.
Can I just stop you? Because you're repeating yourself and you're not answering a direct question. If your answer is there is no prescript that says he cannot do this, and I think that you have considered. If that is your answer, maybe let's leave it at that, because that's all I wanted to clarify. Thank you.
Chair, I'm told here that I'm talking about hard words when I'm saying there's a corruption, and I'm trying to define how I got to those deductions. I get where you're going, that it might not translate to that, but I think it's very imperative that I explain my imperatives, and that's what I just sought to do. Thank you, Chair.
Thank you, Mr. Gxasheka.
Similarly, paragraph 107, you deal with the redeployment of Ms. Tepa, and you say it was handled by Mr. Behari. I, for one, don't propose to take this further. There is a very substantial part of your statement which understandably from paragraph 108 through to 116, it deals with the disciplinary action against Chief Mapie. And again, from my side, I don't need you to amplify anything there. I'm not suggesting that Mr. Mapie is necessarily guilty, but I certainly it's quite clear to me that an employer has a responsibility to institute disciplinary proceedings in the face of these allegations. And I certainly would have no criticism of you for being involved in that. Then at paragraph 117 on page 40, you deal with the...
Well, just before you continue, Mr. Shaswasi, Mrs. Gxasheka, and I'm sure my co-commissioners share this, do not want you to leave this commission with the impression that the evidence leader made light of the very serious allegations that are made here. One, we recognize the seriousness of the allegations, and two, we also recognize the need, as the chief evidence leader just said, for disciplinary proceedings to be instituted if it is found in terms of the allegations, the available evidence, etc., that such proceedings should be instituted. So I thought I should just clarify that.
I'm comfortable, Chair.
Thank you. Thank you.
Mr. Chaskasan, maybe before you do that, still under this topic, Mr. Gxasheka, and I ask you this because it's but it's an issue that was raised with Dr. Mkhwanazi as well. And at least speaking for myself, I think it is important. In paragraph 108.7, you refer to and attach a medical report of the psychologist of what you describe as the victim. I think this is the complainant in this case that you're discussing, right?
Yes.
Okay. Now, when Dr. Mkhwanazi was testifying, the question was asked whether the complainant or the patient she had attached a similar report, if not the same report. And the question was asked how she got the report, whether the owner of the report, that is the complainant, had given permission for this document to be shared. And that's an important question because the records of the commission are public documents. They become public documents. And and this kind of information is regulated by POPIA. You would know that as an HR person. And if there is no permission from the owner of the document to disclose it, we should not be party to further disseminating it by putting it out in the public domain. So I would like to ask you the same question because depending on your answer, the commission then treats the document in a certain way. So I would like to ask you let me ask you the same question. This report, which is LLG 43, how did it come into your possession?
Okay, it's quite a sensitive issue. I think I'm appreciating that we put it at a high level, both for the complainant.
Okay, maybe let me reformulate my question. Just to guide you. What I'm asking is, was this given to you in the course of your employment when this complaint is laid? That's how you came into possession of this, as part of the records of the complaint, okay?
Yes.
You're nodding.
Yes, it was emailed to me.
Yes.
If I recall, by her psychologist.
Okay.
If it wasn't the psychologist, was her lawyer.
Okay.
And I can confirm as well that I think we all agree, let's protect her. She would have even willing to come here, but it's really not worth for her and for Chief of Police.
Yeah,
I think my statement is clear.
My questions are different. It is so that we know how to treat this document in the commission. So you've said you got it in the course of your employment, right? That's fine. Not for purposes of the commission, right? You agree? You nod your head. The record needs to reflect what your answer is.
I have to substantiate my answer because it can be problematic if I don't.
Okay.
I'm going to reiterate. She was willing to come here. And I think we all agreeing, let's protect her. When I went to present her item to Meral, I nearly shed a tear. And she needs to be protected. One thing I can assure you, every document that is here, she knows that is here. We've been communicating. She encouraged it. But I really want to applaud the commission for saying, let's protect both of them.
So you're saying you have permission from the owner of the report to share it with us?
Yes.
Yeah.
Yes, Commissioner.
She knows you're coming to the commission?
She knows.
And that you're going to disclose it to the commission?
She knows.
Okay, thank you.
Thank you so much.
But just to complete that, I had understood you to be saying you would like the commission not to make it public. It must not be in the websites or be shared with other people.
Yes, I thought that's what the commission intends to do. And I said I'm applauding the
Yeah.
commission for that. I highly appreciate that.
Thank you.
Thank you.
Mr. Justice.
Thank you.
Then there is an issue in relation to the 3 suspended employees, Constable Twala, and I'm not sure what the rank of Officers Mackenzie and Stoltz are. You addressed that at page 40, paragraph 117 to 122. Is there anything you would want to add to that? From my side, it's not clear to me that I need to canvass anything with you.
I'm comfortable, Chair. If my statement is sufficient, I'm happy. Thank you so much.
The next topic relates to a remuneration package. And again, this is not a topic that this is not a topic that I need to canvass beyond what's in your statement. I know that there have been allegations that an increase to your salary was granted as a form of reward. I certainly don't intend to pursue them. I see what you say in relation to your remuneration package, and from my side, that is satisfactory for my purposes. I don't know if there's anything that you want to say in that regard.
I'm praying for wisdom on this one. Because the latest is today I'm here. It's still on the public space, being persecuted for it. But because I think our document will be published, I'm praying at some point that the public can understand there was no fraud that was done here. There was no favor that was done for me, an advocate came. In fact, when the matter went to Meral for endorsement, the item went to Remuneration Committee, and then it went to Meral. Dr. Mashaz called me after Meral and asked, how did all those MMC agree that this money be given to you? It's a salary review. I came to the city of Ekurhuleni, quite senior, coming from city of Joburg. I have implemented so many achievements that I have not put here, hence the promotion that I got. I said earlier on when I was in Joburg, I had 3 to 4 promotions. That's how hard I work. The legislation is very clear how you determine remuneration. Between Cocta and Salga, there's debates that are going on, and this money was duly approved by Meral to us. I'm grateful, evidence leader, that you're providing guidance in terms of how we manage these things, because I was going to discuss the matter of Tolan Meza, where when we looked at his document, he got R1 million that we don't know how he got it. But I'm not a controversial witness here. All I want is it must be understood a due process was followed. This process was approved by the by the Meral Committee. Thank you so much.
Can I just clarify?
I think, Ms. Gxasheka, just to understand the allegation here, the mayoral committee had a motivation and support from the city manager, and they see nothing wrong with it because on its face, it looks fine. It's within the bounds that are set by the law. But the allegation was when you and Advocate Behari applied for these positions because you got them in 2023, the salary was advertised, so you knew what the salary was. And a few months later, you then make a motivation that you should be topped up by some 600,000 rand. And the allegation is that the city manager supported that because that was her way of rewarding you for protecting her favorites. So I just wanted to give you that background and allow you to then respond freely to it. So it came in that context that yes, the prescripts allow that you can get to that point, but it would not otherwise have happened but for you and Behari supporting what the city manager was doing, and then she in return supported your motivation, and when it got to council, because they didn't see anything wrong with it, it was not illegal, they then endorsed it. Do you get the picture?
I do get the picture. I want to add, Chair, to you that Mr. Ngiza, who I was his senior from the beginning, by the time I was appointed to the HOD HR and he reported to me, if I can recall events, I think he was already on 2.2 million. And if you recall, when you go to the upper limits, minimum is 2,900,000. I'm no longer responsible for one division. I'm responsible for 5 divisions with all the hurdles and challenges I've articulated here today. Yet there's a junior employee that must be what you call earn more than me. But it was never about Mr. Ngiza. It was about the upper limits. And that needs to be clarified. And the motivation, it came from me and Advocate Kemi, and it was approved by the Remuneration Committee and the Mayoral Committee. And as I say, I don't think Dr. Mashas was too keen on it. It's just that because it's within the law, he allowed it to go. So there's no loyalty related here. It's based on our hard work and it's based on the upper limits of total remuneration package payable to the municipal manager and the managers directly reporting to the municipality, as you said, Chair. Thank you so much.
Thank you. The last topic is the topic that you addressed from paragraph 42, sorry, page 42 to the end of the statement, which is the issue of the vetting of the members of the EMPD. And there, the original allegation is at page 43, paragraph 3.10. And the allegation is that you unlawfully intervened in the criminal record vetting process of the EMPD as administered by Commissioner Spes. That's the allegation. You respond to it from paragraph 42. And maybe you could take the Commission through your response. But before you do that, there is an error in the cross-reference in your statement. So where you, in paragraph 131, you refer to Annexure LLG 51. That's Annexure it should be Annexure LLG 50. And the page reference is, I think it will be file 6 of 6, page 2042. If you can just check that, can you just check for me that I'm right on that the document that you're referring to is the document at page 2042 in the last file, file 6 of 6.
Thank you. Can you repeat your question?
If you look at the statement, paragraph 131 says the emails and legal opinion pertaining to the legal vetting process is attached under evidence C Annexure LLG 51. And I understood that the opinion is LLG 50.
Yes, the opinion is LLG 50.
At page 2042.
Yes.
So just after clarifying that, can you maybe take the Commission through your response to the broader allegation that you deal with from page 42 of your statement?
Thank you, Chair. Firstly, that particular annexure is supposed to come with the emails. I will try and make the emails available tomorrow. I'm sure maybe when we're transmitting, it could have not find its expression into these files. The reason I felt it's important that we talk to the emails sought to refute the statement by Chief that says we just said he must bring the files to HR of what they've done. And number two, it wanted to demonstrate the conversations that went from us having a meeting to us agreeing that let's have a legal opinion. After a legal opinion, what transpired after that? And the most important email, we must get that email, is my last conversation on this issue. I think it could have been when Mr. Mkhwanazi was acting, where I still wrote and said, finalize this process. Legal opinion was clear what needs to be transpired, HR assist, and we had conversations between the Chief of Police, Rivers Peace, and Deputy Chief of Police Mkhwanazi, whereby we're not agreeing firstly about the capacity, how do we deal with this? In their deliberations themselves, the other one, Rivers Peace, he says, I've done my own vetting myself as independently. Here, get the proof. Nonetheless, it has expired. I need to go and do another one. I'm busy doing it. Him alone. The rest must be subjected to a collective process. It started there when they were starting to fight. Then they come and say, this one is updated, it's outdated, we must start a new process, and so forth and so forth. Again, what is good for the cases must be good for the Ganda. In one instance, I'm usurping powers, I'm interfering. When it suits EMPD, they come and say, hey, this is problematic for us, HR, run with it. I said to them, I don't have facilities. I do conduct vetting processes when employee being appointed. I advised them and said, before you can even vet people after they've been vetted, because when we do our initial vetting, you get a consent. There must be consent from an employee. Have you done that? That's my advice in debating the meeting. Those that have reached a threshold in terms of years of criminal records, have you done expungement? They developed a letter. The capacity to vet employees is done by EMPD. Go and use your own facilities. But what you do, this is the process you follow. Drafted the letter, I okayed the letter, and I said, go and do this. The emails that I will demonstrate here tomorrow, I will submit tomorrow, they demonstrate that as late as last year, if it's not the other year, I followed it up that when are you doing this process? This is the same EMPD, by the way, who can't even do risk and security assessment to me. They are carrying firearms. I don't have a firearm. Not that I can't do it. I can suspend, I can do anything in terms of my job. But all I'm saying, let's be clear about roles. We share responsibilities. And when it suits you, you want HR to do your work. I guided them and said, I see the legal opinion, but I'm encouraging you, go and do this process. And the best way of doing it is this way. Lastly, we even discussed how Tshwane has done it. Tshwane followed exactly, they confirmed, Spies confirmed in the meeting that HOD, you correct, Tshwane engaged the employees. There was a consent and this process was done. Expungement was done where it was important. I'm glad that now the leaders, male leaders who are running the city, I can do it even myself, I'm not scared of anything. I know that the process is underway. But tomorrow I must demonstrate that I did follow up and said, do this. Once you have done, concluded it, keep me and the city manager posted. Have they ever done it? No. Didn't I follow? I did. I'll produce that evidence tomorrow. Thank you so much, Chair.
Can I ask that through your attorneys, you email us that email overnight, or that email changes so that we can work on it and we don't waste time tomorrow morning. Chair, that reaches the end of my process of taking Mrs. Gxasheka through her statement. There are a range of documents that we gave her legal team very late last night, in fact, after midnight, so early this morning. Can I ask that we stand down now so that this time can be used for her and her legal team to look at the documents they received at short notice, and that we will pick up tomorrow morning then and start the intrusive questioning tomorrow morning.
Thank you, Mr. Shaskalsin. I see that my colleague, Commissioner Kumalo, wants to raise an issue, but perhaps before that, shall we resume it? And I'm addressing this to you as well, Ms. Magula. Shall we resume at the usual time, 9:30 tomorrow? I think we should, because there's sure to be a lot of questions from all around.
We can resume at the normal time.
At least, especially because we are breaking early today, so that should give you enough time to go through what Mr. Shaskalsin has just referred to.
Yes, Commissioner confirms that we'll do our level best. And
thank you very much.
Thank you. Mr. Shaskalsin, there's just one issue. I think it's only fair that the witness be led in chief on it before they are probed, and it relates to Julius Mkhwanazi's promotion from Director of Special Services to Deputy Chief of Police, and the role Mrs. Gxasheka played in that, and also in the top up of his salary by some 200,000 rands, because Dr. Mashazi, when she gave evidence, said, well, that came from Mr. Mrs. Gxasheka, so you must ask Mrs. Gxasheka about that. So I'm not sure whether that should be dealt by way of this supplementary statement or if it's something she can address now and then she gets probed on it tomorrow.
I think, in fairness, that's a choice for her legal representatives rather than for me. If it's something that would be more convenient to address in a statement, in a supplementary statement overnight, and then we lead on it tomorrow morning, we can do that. But it's really, I think, their choice, not mine.
It will be addressed in our supplementary statement. Thank you, Commissioner.
Thank you.
May I perhaps request the evidence leaders to assist in identifying the places where this is to be found in the record? Thank you. I know
We will do that.
I'm heading to
I
your
see
plate.
that you're looking firmly at Ms. Boy,
I see
for
Ms.
which I am
Boy-
grateful.
I see Ms. Boy does not even want to look at me. She's looking down. Thank you very much. Let's adjourn and resume at 9:30 tomorrow morning.